All right, we're going to talk about a gazebo today. Yeah, a simple portable backyard gazebo. Sounds totally harmless, right? Well, this particular one kicked off a year-long legal war between a homeowner and our HOA. And believe me, the outcome has some huge lessons for anyone who owns a home.
I mean, really think about that for a second. Could that new patio set you bought, or that little garden shed, actually spiral into a legal nightmare? For one homeowner, the answer was a huge yes, and it all started with something you'd never expect.
So here's how we're going to break this all down. We'll start with the gazebo itself, and then we'll track how this whole fight just got bigger and bigger. We'll look at what the judge finally decided, and then dig into the why, the two key reasons the HOA came out on top, and then we'll talk about what this all means for you.
Okay, let's set the scene. We're in Tucson, Arizona, and a simple backyard addition, something that's supposed to be for shade and relaxing, is about to become ground zero for a major conflict.
It all kicked off in late 2005. A homeowner, Laura Frey, puts a portable gazebo in her yard. Seems like the most normal thing in the world, doesn't it? But what she didn't realize was that her homeowners association, TEPOA for short, was watching very, very closely.
And this is where things really start to go off the rails. What started as, a simple request from the HOA quickly snowballed into this storm of official notices, formal hearings, and some serious financial penalties.
So what was the big deal? Well, it came down to this one rule in the HOA handbook, the 10-foot setback rule. It meant no structures, temporary or not, could be within 10 feet of the property line. And yep, you guessed it, Ms. Frey's gazebo was sitting right inside that zone.
This is where both sides really dug in. Ms. Frey's whole argument was pretty simple. Hey, it's not a structure. It's just lawn furniture. But the HOA, they saw things completely differently.
And just look how fast this thing blew up. March 2006, she gets the first notice. By August, they're already hitting her with fines. And just a few months after that, things get even more serious.
The HOA decided to apply some real pressure. They slammed her with a $10 fine per day. Every single day that gazebo was still standing, that bill just kept getting bigger. You can imagine how fast that adds up.
And believe me, it wasn't just about the money. The HOA suspended her right to vote in community elections, and get this, they even locked her out of shared stuff like the pool. They were basically making her an outsider in her own neighborhood.
So after a year of fighting these fines and restrictions, Ms. Frey took the next step. She took her case to an administrative law judge, really hoping that the law would finally see things from her perspective. But it did not go her way. Not at all. The judge's decision was a slam dunk, a complete victory for the HOA. The fines were upheld, and everything the association did was validated. So the million-dollar question is, why?
Okay, let's pull back the curtain and look at the legal reasoning here. The judge's entire decision really came down to two surprisingly simple but powerful points of law.
So everything hinged on this one critical question. What actually is a structure? Was Ms. Frey right? Was it just some fancy lawn furniture? Or was the HOA on the money? The whole case depended on this. And here's where it gets kind of wild. The court didn't get into some complicated legal definition. Nope, they just pulled out a dictionary. They went with the plain, ordinary meaning of the word, a structure is simply something constructed. And by that super simple definition, the gazebo was, without a doubt, a structure. End of story on that point. It totally demolished her lawn furniture argument. And here's a crazy detail. At one point, the gazebo got damaged, and she put up a trellis instead. And the court said that was a structure too. Now this was Ms. Frey's second big argument. She basically said, hey, the HOA ignores this stuff all over the neighborhood, so why are they picking on me? And that's a pretty common defense, right? You argue that the HOA has waived its right to enforce a rule by not enforcing it on everyone. But, and this is a huge but, the HOA had a legal trump card buried deep in their documents. It's something called a non-waiver clause, and it is incredibly powerful. It pretty much says, hey, just because we looked the other way yesterday doesn't mean we can't enforce the rule today. This one little clause made her entire argument about other violations totally irrelevant. It was like a legal shield for the HOA, letting them enforce the rules whenever they wanted to, no matter what they might have ignored in the past.
So, a complete loss for the homeowner. Which brings us to the most important part of this whole story. What does this cautionary tale mean for you?
Let's boil it all down. First, remember that a structure can be pretty much anything you build or assemble. Second, those HOA documents, they are a serious legally binding contract. Third, that non-waiver clause is a real game changer that gives your HOA massive enforcement power. And finally, and maybe most importantly, these little disputes can turn into big, expensive problems way faster than you think. The real lesson here? Read the rules before you build anything.
You know, we all learn the rules of the road so we don't get a speeding ticket. But this whole case leaves us with a much bigger question. Have you spent as much time learning the rules that govern the single biggest investment of your entire life? It's definitely something every homeowner should think about.